Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Hey, welcome back to another episode of Just Verdicts. I'm your host, Brendan Lupetin, and today I'm excited to be joined by Bob Janssen, Zach Janssen, and Ryan Froelich, who are going to be talking to us about a great UIM verdict that they got recently that I read about in Trial Magazine and wanted to learn more about. So, gentlemen, thanks for being here today.
Thank you.
Thank you.
So, two of these attorneys have the same last name, and I believe you guys are related. So, why don't you guys talk to me about the firm? You know, Ryan, Bob, Zach. How do you guys work? And and as a father of three younger guys, I do also want to hear what it's like working with your dad versus and working with your son too.
Sure. So we have really a smaller firm here in Green Bay, Wisconsin. We have obviously the two attorneys here, and we have another attorney who does extensive brief writing, Katie Verbord, excellent brief writer, does substantial work for us in that area. I left my older firm in 2016 and really had planned on just having a one-man shop doing personal injury and workers' comp, but things got busy real quick. Just started getting referrals from doctors, former clients, and literally I had cases and litigated cases against Ryan, and we just struck up a conversation, and I said to him, I'm absolutely swamped. I need to hire someone, and not even thinking where it would go. And before I know it, I was able to rope Ryan in to leave a very successful defense practice firm. And then a few years later, Zach had been working with clerking for a very good law firm in Milwaukee doing defense work. I think Danny Mullen, very good lawyer out of Milwaukee, was his supervising attorney. And Zach said, hey, I want to come back home. And I said, well, you're going to work harder than me, and you're going to work more hours than me. And if that's of interest, great. If not, that's okay. Move on. So that's sort of how it all has gone.
Ryan, high praise for you being, your opponent on cases reaches out to you and asks you to join his firm. What was that like, switching from defense to plaintiff? And probably somewhat flattering to have somebody like Bob, ask you of all people to come help out.
Well, as there's a lot of things that are always going on behind the scenes with the story that Bob just shared. And, I had been in practice doing insurance defense for about 12 years or maybe 11 years at that time. But what Bob didn't realize when he told me about his situation was I was desperately looking for an off-ramp from insurance defense for a lot of reasons. I mean, professionally, personally, and I was even looking at opportunities outside of practicing law. That's how rough it was getting for me doing the insurance defense. And so I think what Bob actually told me was, I'm so busy, I'm interested in even hiring someone just out of law school. And I remember, I think it was that same day I called my wife and I told her, because she knew about Bob just from our past cases together. And she goes, well, who cares if it's a law clerk or a young attorney's looking for, tell them you're interested. And that hadn't even occurred to me, but she's a lot smarter than I am. And so I reached out to Bob, and I think he actually thought it was almost like a prank at first that I was interested in coming over. Yeah. But yeah, I was so thankful and love working with the guy and with Bob or with Zach as well. So
awesome. Very cool. And Zach, how about from your perspective? What's it like making the switch? And obviously you have to say the right things because your dad's on here with us, but what's it like working with your pops and Ryan as a young attorney up and coming?
Yeah, I think for starters, it was a big change, I think, in the first 6 months. Definitely took a few months to get used to, it needs to look like this. You need to be here at this time. things that would otherwise be a lot easier critiques from other people who maybe I hadn't grown up with my entire life. I had no problem taking critique from those people, but I think when it's your dad, it's sometimes a little bit more personal. But I think really after 4 to 6 months, that conversation changed. I think things got a lot smoother. And really today it's the difference between going over on Christmas and going to work. I mean, we can have mature conversations. It's not, taking things personal like it felt like in the first few weeks, and it's a great situation here.
Yeah, I can imagine that dynamic because there's always that, when you've got kids, it's like everything you tell them seems to go in one ear out the other, but somebody else randomly could tell them the same thing, and it's like they have this big aha moment. Mm-hmm. There's just something packaged into the parent kid dynamic there. But it's awesome that from your perspective, it sounds like it works itself out. And then you guys have this kind of, good, obviously personal family relationship while also that professional level of, sort of like mutual respect, it sounds like, which is really cool.
Absolutely.
So we're here because I read about your verdict in Trial Magazine, and I'm not sure we've really talked about a first party UIM case before, and I think a lot of lawyers, myself included, I don't think I've ever actually tried one. Actually, I've gotten very close, but they always seem to settle. So I think a lot of our listeners would be very interested in sort of the dynamics and how you approached trying a UIM case. Again, on the one hand, it's like, wow, you're suing an insurance company, but there's some other aspects of it that are kind of unusual. So why, whoever wants to jump in, why don't you, and I think Ryan was telling me this was sort of your case you'd worked up, and then Ryan and Zach jumped in. So why don't you give us the backstory of the case, how it came about, and why it had to go be tried?
Sure. So to give you just the short synopsis, Tina, who was my client, this is a typical cold weather Wisconsin, Green Bay, frozen tundra day. It's snowy. It had stopped snowing. My client actually had her son, who had just gotten his driver's license. He wanted to get a sub sandwich, and he was set to go. And she said, "Whoa, the roads aren't good enough. I'm going to drive you." And they got sort of in a discussion about that. And ultimately, she decided, "I'm going to drive you, and we can get a sub." So she pulls up to a stop sign, and as happens how many times, right? She gets smashed, rear-ended by a big Chevy Tahoe. Smashes out her rear window of her van. Doesn't immediately go and get treatment. A couple days later, goes to a chiropractor. Doesn't get better. Is having neck pain. The neck pain isn't going away. The chiropractor treats her for an extended period of time. Just is not getting the results. Trying to live with the chronic pain, ends up at a pain management doctor, Chris Housen, who's well known, extremely well credentialed in Green Bay. And he does injections, does RFAs, radiofrequency ablations, and they do provide symptomatic relief. I mean, very good relief, but unfortunately the pain comes back. And so we then proceed. We have initially Progressive was on the other side, Progressive Insurance. They pay their limits of $100,000.
And that would be the policy for the driver that hit your client.
Exactly. Our client had $500,000 of underinsured motorist coverage limits. In Wisconsin, they allow reducing clauses. So you reduce that 500 by 100 that was paid. So now we're fighting over the balance of $400,000. We proceed through depositions. Ultimately, we mediate the case. At mediation, the proposal by Wadena Insurance Company is $45,000. The medical bills alone were $93,000. But Wadena just thought incorrectly that they'd offer $45,000 and take or leave it. The last thing the mediator said to me was, Wadena told him that 45,000 is it, and if you want to get more, the jury will have to tell us to pay more. And that was really the end of it. There was no further discussion about increased offers. Uh, so last year in December, on again a blistery, cold, snowy day, probably very similar to the day of the accident, we try the case for a couple days in Brown County. So that's sort of the brief synopsis.
Yeah, absolutely. So, so you got UIM. So you're suing your client, Tina Hannon. Her insurance company, Wadena, is saying, you got your 100 from the other driver. We'll give you another 45K. Take it or leave it. And Tina didn't. It sounded like she did not have surgery. Is that right?
That is correct. And, Green Bay is a pretty conservative market, I will say. And so we had to fight, I would say, that initial response to many people that, well, there's no surgery here. She's still working full time, had very little time off from work, and she's doing pretty much everything she could do before. Her husband was also a party in the case, Brian, great guy, very stoic, quiet guy. But yeah, so that's sort of how it went.
And so, is there a claim then that she's going to have sort of ongoing chronic pain from this?
Right. So we introduced that through the chiropractor, very well known local chiropractor, been around for probably 35 years, I think now, Rob Service, and he testified live and did a great job, as did the pain management doctor, Dr. Hausen. You probably know this. If you can get your doctors to testify live versus a video, it is night and day. It's a game changer, at least from what we've seen.
If they're good, if they're compelling.
Right. If they're not, yeah, then it can be a
But then
dark.
they were probably going to be bad on video anyway. But
Absolutely.
Ryan, I'm curious because you wore the defense hat for so long. How do insurance defense firms typically look at one of the primary medical testifiers being a chiropractor?
Yeah, I mean, Brendan, that definitely was a shift for me coming over to this practice and knowing that a lot of our clients, I mean, they receive relief from chiropractic treatment, and that's a very real thing. What I'm seeing more and more now though is chiropractic is a component of treatment, but a lot of chiropractors we work with will ultimately refer clients on for pain management. And so there's actually a pretty good relationship between pain management and chiropractic in Green Bay. Um, yeah, chiropractors, like any healthcare provider, they rely heavily on the history that their patients provide. And I mean, if we have clients that are credible, we believe them. We think it's reasonable for the chiropractors to believe the subjective, complaints that they're making. And I mean, honestly, Brendan, what I think I bring from my defense background is like any attorney would, but I really work over pre-existing records and prior records and have those hard conversations with clients early on that, hey, this is a reality of your case. You have these pre-existing conditions. You have this treatment history. We're going to have to deal with that. And we were able to roll out Tina's prior history, but then use our treating doctors to distinguish between what existed before this crash and what she dealt with in the 5 years after the crash leading up to the trial. And the jury saw it clear as day.
What was her? I mean, so what pre-existing did you have to contend with? And how exactly did you go about trying to parse that out so
Yeah.
the jury could see, a real change before and after?
Bob, I'll defer
Yeah.
to you on
So
that.
she really did not have any extensive prior chiropractic treatment. certainly no ongoing care. And, that was unique. Many cases you don't have that. And, but of course, the insurance medical doctor, when you look at x-rays, MRIs, all those kinds of things, they latch on to that and claim that she had this pre-existing condition and it was going to heal anyway. Um, and she would have been pre-accident condition shortly after. And that's the mantra they took as part of the case. There was a unique scenario we had here. Wisconsin has the emergency doctrine, which, you can skirt liability if that doctrine is applied. And here we had sort of bad roads and things like that. And so we really tried to eliminate that argument, and we brought a motion for summary judgment, literally on liability. And Zach handled that, and Zach, you handled the directed verdict that we tried to get. And the judge we had is very experienced, has done many, many cases over the years, but just thought that any personal injury case has a issue of fact involved.
So that was still an issue at trial.
Well, interestingly, there had been indications that they were going to admit liability, and I think it was a dramatic error by Wadena in not admitting liability, because then really you have your enemy, right? You have your target. It's not the opposing driver at all. It's all about accepting responsibility and just never accepting liability. And we brought that up many times, and I think it carries in every case where there's clear liability.
What did you guys focus on going into a case like this? So you've got pre-existing conditions, you've got chiropractic treatment, you have insurance defendant, but somebody else that actually hit your client. What did you try to focus on, to the extent there was much voir dire in your jury selection process?
So in our voir dire, many attorneys nowadays, when I first started practice, was not even a consideration. But nowadays, right, you weave your opening argument into your voir dire. So you ask jurors, you say, you'll hear testimony that Tina had, dry needling. She had prescription medication, Botox injections, RFAs. And then I went through each one. I said, you're going to hear this. She's had this invasive treatment. Have any of you had this? And in many instances, no one even knew about it. But you're telling them about all these treatments she had following this accident. So the foundation, I think, is really laid right in the voir dire immediately. So
any other questions you guys focused on as far as the dynamic of suing an insurance company, or anything else unique going into a UIM trial like this?
I think I'll let Ryan, maybe you can address how we approached this. It's a first party claim, so you're buying insurance through your own insurance company, and you have to walk that in Wisconsin. You have to walk that tightrope of really trying to make this a battle about insurance. Many times judges don't want to allow a lot of that discussion in, but Ryan had brought up this idea to me about his closing, and I remember talking to him before trial, and he sort of gave me, this is my thoughts, and I was like, man, I'm not sure about that. And but I'll let you, Ryan, sort of describe how that closing went, and the jury bought it. I mean,
Yeah. So, yeah, at trial, our clients were suing their auto insurer, Wadena, for its refusal to pay damages under its underinsured motorist coverage, so a first party claim. And, when you start talking to just lay people, start talking to jurors about insurance coverages, I mean, folks' eyes glaze over, and it's so boring. So during closing, I actually began by asking the jury to just kind of sit back and imagine this scenario. We wrap up this trial, and everyone on their way home stops at their neighborhood grocery store. They go through the aisles with their cart. They're, picking out items. They get everything they need, and they come up to the checkout counter, and they start, putting their items on the conveyor belt. They're being, checked off by the clerk, and then the items are being bagged and put back in the cart, and the store clerk rings it all up, and it's $100. And our jurors, pay the bill in its entirety and start walking out to the parking lot, and out to their vehicle. And I kind of stop, and I was like, so that's a normal outing at the grocery store, right? Everything happened exactly as you'd expect, but then something unexpected happens, and I want you to, try to picture this in your minds. The store clerk runs out behind you and stops you, and then he begins actually taking some of the items out of your grocery bags, the things you just purchased. And then the clerk basically thanks you for shopping at the store, wishes you a good day, and walks away. And I asked the jury, I said, how would you feel? You'd be left standing there confused. You're feeling angry. You're feeling like you just got, scammed or kind of robbed to some extent. And I said, you're not getting back any of the $100 you just paid that store, and you're not getting all of the groceries that you paid for. So I compared our client's experience with their auto insurer to this grocery store scenario. And I said the Haynens, they selected numerous coverages, including underinsured motorist coverage. They paid for all these coverages. And then after this motor vehicle collision, they claimed underinsured motorist coverage. But Wadena, for 5 years, refused to pay a penny under that coverage. And I mean, Brendan, I remember, making eye contact with each of the jurors, and a bunch of them were nodding. I mean, they understood right away at the beginning of that closing what this case was really about. It wasn't so much, it was about injuries, it was about the suffering, but it was really about kind of this betrayal of trust between an insurance carrier and its, customer.
And everybody hates not getting what you paid for, right?
That's right.
Yeah. I mean, the more that you can show it for what it is, that they dutifully pay their premiums over and over and over, and then when it actually comes time for the other side to hold up their end of the bargain, they take the food out of the bag, so to speak. Mm-hmm. So I think that's a terrific analogy. So you guys get into the trial, and you're having to try this case. What was the delegation of? How did you divvy up who does what? We've got a 3-man team here. So how did you guys approach that?
I had done most of the work. Zach, we wanted to make sure he got some experience with motions and, just experiencing the heat of battle and
got to get in there.
Yeah,
got to feel that trial experience, what it's like to be in there.
Stand up in front of the judge and argue your motions and I really thought it would be helpful to have Ryan give a perspective, I think, that I never thought of at all, and a example or a scenario that I'd never thought of, and even when he ran it by me, I wasn't sure of, but I had trust in him, and it really, I think it turned out exceptional. The insurance medical doctor that we had, Brandon, I don't know if you've done this, but when we did his trial depo, the first question I asked was, "Hey, doctor, I just want to make sure we understand, what happened here. What is your understanding of how this collision occurred?" And this doctor, mind you, every person in this courtroom knows that this is a rear-end collision. The insurance doctor says, "Well, I believe it was a T-bone accident." And, you could just see people were looking around like, wait a second, the judge said it's a rear-end collision. Both attorneys said it was rear-end collision. Where's this guy coming from? So I've always, that's happened probably in 3 trials I've had, where I've asked just a real basic question that comes up, and the insurance doctor just gets it wrong. And from then on, it doesn't, I didn't think it went very well for them.
Well, I think the beauty of that too is, while, Zach, you probably learned this in law school and you hear, never ask a question that you don't know the answer to. But there's a lot of questions where, there's no, as long as there's no bad answer, then it's fine to ask. And you might get a great response like that. So maybe he did know and he says, yeah, it was a rear end at a stop. And then you move on. Okay, good. And it's like, it's a nothing. But you might get a great response showing that, this person is out of touch. They didn't do their homework. They don't really know what this case is about. And that's going to immediately, taint their credibility going forward. Zach, let me ask you a couple questions. So did you, and this is more out of curiosity for my kid's interest, did you ever see your dad try a case when you were younger? Like, did you ever go to court at any point in time before you started practicing with him?
No. I think I had seen a deposition or two, and certainly many conversations around the dinner table
Sure.
about any car collision or fireworks accident that you can imagine. But really nothing in a courtroom, and really had very little understanding of the legal process, other than the fact that people were getting hurt all the time.
Yeah.
I know that sounds crazy, but that's really, that's what it was like growing up. So
No, I totally get that. I'll talk with my kids sometimes and, they know what I do generally, like what it is. But, my one son asked me, like, I don't get why did they get money? Like, do the people go to jail? And you're trying to explain to them, well, we have these, there's for, mistakes and errors that aren't quite criminal. We have a civil justice system and trying to get that across. But none of my kids have come to one of my trials yet. And sometimes I'm like, oh, maybe I should be, forcing them to come in and see me. But what, from your perspective, Zach, what was it like, the first time, being in an actual trial, with your dad? What was that experience like?
it was pretty intense, I felt. I mean, as weird as it sounds, there's the client actually was pretty stoic. I thought she did a great job testifying. I actually felt like we were, more of the nervous ones in this situation, understanding what was on the line. But it was incredible to see firsthand, people who have been doing this for years and years and years, and I really hadn't had much exposure to it at all. And I thought the trial prep was fascinating, preparing each step of the case, as if any point in time the fact that you tell could, make the deal breaker. I thought it was intense, but intense in a good way.
Yeah, it's a pretty fascinating process when you first get into it. Bob, so Ryan shared, that great analogy in his closing, to try to, not try, but did drive that point home of what really is happening here. How did you go about explaining what the case was about in opening in a way like Brian said that, hopefully wouldn't cause the jury's eyes to glaze over with boredom about insurance coverage?
Yeah, when I think it may be Dave Ball's book. He references, and I thought this is always good. In your opening, I said before we came here today, we thought we needed to do this for you to prove our case. Before taking your time here today, we thought it was important that you knew this. And that seemed to work pretty well. We had two clients, Brandon, that were very quiet people, very reserved. Uh, I spent hours with Tina's husband trying to find something that he could testify to that showed a difference in their life, and it was a struggle. I mean, it went on and on and on, and finally he said, the one thing I miss most, he said, the one thing I miss most is being able to plant flowers with his wife. So that's really what we, you know, focused on, as bizarre as that sounds, in his testimony.
It does. That doesn't sound bizarre to me. I honestly,
Yeah.
the more I talk with other lawyers in these podcasts, the more I think finding a handful of very specific, anecdotes like that in their life is so much more effective than like, give me on a scale of, 1 to 10 what your pain was like, you know what I mean? Like that kind of stuff. Like those, it's just a little bit different and it interferes with our life now. And here are some specific examples that are important to us. They might not be important to everyone else, but, I think that is the best way to get people to understand the impact.
Something as basic as planting flowers, Brandon. I mean, who would think, right? But Tim was a big deal. They have 5 kids, very active, and it's the one thing he could spend with her, and just those two planting flowers. I mean, it was amazing, and clearly the jury, they compensated him. I think the verdict was $50,000, and before we found that, I thought they were gonna say, we'll give you $500 and a pat on the back. I mean, there just was no connection. But when he was able to make that sort of example of how their lives were affected, it proved pretty, impactful. Yeah.
Tell us about some of the other sort of, whether they're turning points or key moments in the trial that you think, led to this verdict.
I thought we had the Dr. Hausen bring in an actual syringe, a similar syringe that he uses for these injections, and I thought that demonstrative evidence was extremely helpful. Um, Wadena did not have a person at trial, so through the whole trial, um, there was no representative from Wadena there. So we, I think I may have been the one who said, everyone says, "Where's Waldo?" And we said, "Well, where's Wadena?" And they were nowhere to be there. And the opposing attorney, in fairness to him, Todd Dickey, a great lawyer, will try any case, has no fear whatsoever, very learned, experienced. But I just think when you're put in that spot as a defense attorney, liability is clear, and you're trying to, you can't admit it because they won't let you admit liability. It's a tough spot to be put in.
Yeah.
How about Ryan or Zach? Anything jump out to you as far as, what you felt was particularly compelling or connected with the jury?
Well, we were talking about this just a couple days ago, getting ready for our meeting with you, Brendan, and it was something that actually didn't happen in the courtroom that I think weighed heavily on the outcome of this case. So the trial was December 3rd and 4th of 2024, and we had I think we had a couple witnesses to put in still on the morning of December 4th. And then, the judge went through his jury instructions and all those things. And so we were arguing in closing by, I don't know, maybe mid-morning, maybe after lunch, I don't recall. But the morning of December 4th, 2024 was the incident in Manhattan where Brian Thompson, that United Healthcare CEO, was fatally shot by what was his name? Luigi Mangione. And I remember as that news was coming out, kind of the national sentiment was not so much like sadness for Mr. Thompson's family, but it was almost this outrage against the insurance industry. And I mean, we know in the weeks and months that followed, Mangione was almost painted as like this folk hero in some ways, as heinous as his crime was. But I think there was some connection with the sentiment that the public was having as it learned about that crime, with how our jury was feeling when they saw this case teed up before them as a denial of a claim, a just claim. And so it wasn't something we were doing. We just laid out the facts of our case, and the news cycle just happened to coincide with the most important period in our trial, which was, I think, the culmination, the closing, and then deliberations. And the jury, I mean, almost exactly followed what our recommendations were in closing with regard to damages.
Which were what? Walk us through how you approach that, and
Yeah.
what you were asking for if you're in a if you're in a state where you can ask for a specific number.
Yep. So one of the things that we did before trial was we prepped all of our exhibits, and a bunch of these exhibits were more like demonstrative aids, and one of them was kind of a poster board of this, what we had anticipated the special verdict would be. So it had, all the categories of damages: past medical bills, wage loss, mileage, out of pocket, future medical bills. And we left those things blank, but we kept introducing that poster board throughout Bob's examination of witnesses. And what we did was, with our treating doctors, we had them actually write in what the past medical bills were for their treatment. And then when we got to future treatment, we had them write in, kind of the calculation that would lead to that ultimate number we were asking for. So the jury never saw Bob or I write those numbers down. They only saw the treating healthcare providers do it. And when we got to my closing, I just held that up again as a special verdict as I'm walking the jury through it. And I'm saying, hey, you guys remember, Dr. Housen said this, and he wrote this number. Dr. Service said this, and he wrote this number. And again, the jury, they understood that was coming from these credible expert witnesses, and they easily followed all of the economic damages that we requested, including the future treatment, which is pretty surprising because it wasn't surgery, it was all chiropractic and pain management in the future. And then we laid out our non-economic damages of past pain, suffering, disability, and future, and the loss of society and companionship for Tina's husband. And I think Bob, correct me on this one, but we asked for just over, I believe it was 700,000 in our closing, and the jury awarded like 694,000. So they came awfully close to what we were asking for.
That's a really cool way to use a demonstrative, throughout trial, and then that becomes essentially your centerpiece or one of them in closing, and that credibility component of having the provider supporting those numbers write them in.
Yeah.
In closing, did you suggest numbers for the non-economic slots?
Yeah, we did do that, and it was more ranges, and I don't think we ultimately said specific numbers, but we provided ranges, and it's about honoring the jury's discretion in that, and also just saying this is ultimately your decision. I mean, we're here today because essentially this insurance company has forced us to be here by paying nothing, and so it's your job now to establish the value of this case and ultimately force Wadena to do something about it.
How did the three of you come up with the suggested ranges or proposed ranges for the non-economic claim?
Boy, that's a great question. Wisconsin, I keep saying this because traditionally Green Bay has been, for a non-surgical claim, to get these kind of numbers was just substantially higher than I think. So, I mean, we thought for past pain, ultimately the jury awarded 175,000 for past pain and suffering, and future of 125,000. And I recall, Ryan, you had mentioned numbers very close to that. And we thought that just, this is something bigger because you're now involving injections and you're being invasive with your treatment and you're taking pain to get rid of pain. Those kinds of arguments increase the value of that case. There was a real interesting part of this. We always interview the jury after the case is done. We hire someone to do that. And ironically, virtually all of the jurors said your two experts were exceptional. They were clear, concise. We could follow what they were saying. There was one, I'll never forget this, one female juror, an older lady. We talked to her, and she said that insurance medical doctor was spot on. Um, and she was the only one, and she said, I just couldn't believe that everyone else disagreed with me. I just thought that insurance medical doctor, was spot on in his analysis. And um, so you just never, right, Brandon?
It
You
just
just
goes to
never
show
know.
you can't please all the people all the time, and that's why it's at least in PA it's 10 out of 12. I don't know what
Yep.
yeah.
So we
So
got, yeah.
and it's critical for that, and it accounts for the outliers and the minority in those situations. So if you guys had to try the case over again, is there anything that you would do different, or were you generally pretty pleased with how this case unfolded? Obviously, you got a great outcome that destroyed the top offer.
Boy, any thoughts, Ryan or Zach? What do you guys think?
Nothing comes to mind for me. I think the points that we needed to hit on, we knocked out of the park at the end of the day. And I think that, for as many jurors as we interviewed, I think, we did as well as we could have done.
That's awesome. I mean, I always look back and usually, I mean, in my great outcomes, I'm like, no, the things that when it could have gone either way went my way. I didn't make any major mistakes, and that's sort of how that happened. And obviously, in our losses, we can always find more spots where could have improved this, could have improved that. Have you guys used that demonstrative in prior trials, or was that something that you kind of came up with specific for this case?
This was the first time, right, Ryan, that we've used it.
Yeah, I think it's something that I I've definitely used when I did defense work. I definitely used a special verdict type exhibit, just to so I didn't have copious notes that I was working off it. It's just a nice way to to interact with the jury more, and like you said before, Brendan, have kind of the centerpiece that I keep bringing the jury back to. But I've seen it in some of the CLEs I've been to, and just kind of tucked it away as this is going to be it's going to be a cool way to use it at the next trial. So.
Yeah, I think that's great. And so top offer was 45,000. What was the ultimate final verdict all in with both claims?
694.5.
Very cool.
694,500. So it was a good day.
And did you get any sourpuss emails from the insurance company at any point, or did they just quietly nod and pay, or how'd
So in
that all work out?
Wisconsin, yeah, so we got, costs and interest. Um, but no, we just, there was no battle over the costs. Sometimes you battle over experts and all
Sure.
that kind of stuff. There was none of that. I think they just were set to move on to their next case. And, the only other what I thought ironic part of this case was we are waiting for the verdict, and our clients say, you know what, why don't you just call us?
They took off.
First time I've
They
ever
did.
seen that in 37 years.
Yeah.
My client I think they were offended that the Wadena was not accepting liability, their own insurance company. They contested every part of her injuries. And at the end of the day, it was more, they just wanted to have their case heard. And the verdict comes in and they're not in the courtroom.
Yeah.
It was just pretty a unique situation that I've never experienced before.
Well, I mean, at first blush, you're like, oh man, they didn't care about their case. But I actually think that actually speaks to, what the purpose for that suit was for them. It was not so much about the money. They're not sitting there waiting, like rubbing their hands and how much money are we going to get. It's more, hey, we said our piece, we made our point, whatever happens, happens kind of thing. And I think that's pretty cool.
Exactly.
Yeah.
Yep.
That's a great point.
Yeah, That's awesome. Well, gents, that's a great outcome, a cool story, a lot of really interesting tidbits and trial strategy that you shared with us today, which I loved. So next time you guys hit a big verdict, let me know. We'll do this again because it was really fun talking with you guys. Again, Bob Janssen, Zach Janssen, Ryan Froelich, thanks so much for being here today talking about the Hanen versus Wadena case, and really appreciate you guys.
Thank you very much. Appreciate
Thank you very much.
Okay.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.